Hello everyone, I welcome you once again to another video lecture of subject Private International Law in BBLLB department. So I hope you all are doing good, you all are safe, your family is safe. So today we'll proceed with renvoi. So in last class we did about the types of renvoi, that is the single and double, how the judges interpret the each case and how the cases proceed in the international court or any court of international jurisdiction, how and from where the cases changes depending upon the nationality and domicile of a person. So here in this lecture we will again look forward and have a deep study of renvoi. So now we come to the objections of the doctrine. The doctrine of double renvoi is mainly applicable in England, North America and Australia. The main point of objection is that the doctrine, objectionable in principle, is based on unconvincing authority and cannot be said to represent the general rule of England law. The total doctrine does not ensure uniform decisions. Those who favor renvoi desires that the same decision shall be given on the same dispute fact, irrespective of the country in which the case is heard. In truth, the doctrine of renvoi will produce this uniformity only if it is recognized in one of the countries concerned and rejected in other. Example, the law of the domicile to which the English judge is referred requires that the case is to be decided exactly as the English court would decide it. What is the judge to do on finding that by the English law his decision is to be exactly what would be in the country of domicile? When will the process of passing the ball from one judge to another stop? There is nothing apparent as to how this circle can be broken. Uniformity will be attained if the law of the domicile repudiates the doctrine of total renvoi, that is, if instead of seeking guidance from foreign judge, it provided that the national English law shall govern the matter, for in this case the English internal law will apply and harmony will prevail. It seems difficult to justify that a particular doctrine will work only if the other country rejects it. The fact is that uniformity of the decision is unattainable on any principal doctrine with regard to the matter that are determined in some countries by the law of nationality and others by the law of the domicile. The doctrine of double renvoi signifies the virtual surrender of the English rules for the choice of law. If one removes the technicality of this doctrine, it is nothing but a substitution of the foreign law for the English choice of law. Example, British subject who dies in a state domicile in Italy, the English law selects the law of Italy as the governing law, but the Italian law rejects the English law. So when the English judge referred to the Italian judge would have done, the English judge applies the internal rules of England and thus shows preference for Italian law. The English law is dropped as it does not meet with the approval of the lawmakers of Italy. Moreover, the application of foreign country law may be unacceptable for public policy issues in England. The English principle, for instance, that an in-estate movable shall be distributed according to the law of his last domicile, is founded on the reasoning that rights of the succession would depend on the law of the country where the deceased established his permanent home. Thus, if the reference to the law of his domicile means a reference to the internal laws, including private international law of that country, then not only is the policy of English law reversed by the probable intention of the person concerned, is ignored and flouted. He may, for instance, have refrained from making a will, having been content with the local laws of intestacy, believing that the law would be applicable in the event of his death, but it does not. So total renvoi is difficult to apply. This doctrine makes the English judge ascertain as a fact the precise decision that the foreign would give. This has two difficulties. Number one, he must ascertain what view prevails in the foreign country with regard to the doctrine of single renvoi. Secondly, where the foreign law selects the national law of the person concerned, the English judge must ascertain what is meant by national law. The chosen law that emerges from an application of the doctrine depends on whether single renvoi is recognized by the law of the domicile. If the court of the domicile would accept the remission made to by English law, it would then determine the case according to its own internal laws. Otherwise, it would apply the internal law of England. This dependence of the rights of the parties on the attitude of the law of the domicile towards the renvoi doctrine is cause of acute embarrassment, as it becomes difficult to obtain reliable information, suggestions because of lack of uniformity of expert witness on in the process. So next difficulty that may arise is to ascribe a definite meaning to the expression national law. When the private international law of a country to which English judge is to refer selects the nationality of a person as that concerning factor, it becomes necessary to correlate the national law with internal law, but which the issue before the court may be determined. This is a simple matter when the person is national of some country like Sweden, which has a unitary system of territorial law. There is a single body of internal laws applicable throughout the territory of Sweden. The position is different by the country of nationality if a country like India, Britain, England, or in Scotland, where there are several systems of territorial laws. So we come to one of the case of O'Keefe case. The question before the English court was where in the movable of X, a spinster who dies in estate, were to be distributed. X's father was born in 1835 in Ireland, but at the age of 22 he went to India, except for various stays in Europe, lived there throughout his life, and died in Calcutta in 1885. X, born in India in 1860, from 1867 to 1890, she lived in various places in England, France, and Spain. But in 1890, she settled down in Naples and resided there until her death 47 years later in 1937. So about the year 1878, she had made a short tour in England with her father. She never lost her British nationality but was domiciled in Italy. The English court, as per private international law of the England, selected the law of her domicile. But had an Italian judge been hearing the matter, he would have referred to her law of the country of which she was national, that is Britain. Italian judge would have rejected any remission made to him by English court, as single renvoi is not recognized in Italy. Now, what system of internal law out of those having some relation to X would be regarded by Italian court as applicable? Whether it was the law of the England, Ireland, India, which of these systems are to be selected by the court of Italy if the Italian judge would have been hearing the matter? The expert witness agreed that the choice of law would be the law of the country to which X belonged. At the time of her death, she certainly did not belong to England for applying the English internal law, for she had spent not much time in England. She might perhaps, by reason of her birth in Calcutta, be regarded as belonging to India. But she had not been in India for 70 years. It can also be believed that she belonged to Italy, as she had continuously spent the last 47 years of her life in Italy. But the judge reverted to X's domicile of origin and held she belonged to Ireland because that was the country where her father was domiciled at the time of X's birth, although she was born in India. So in the result, therefore, the succession to her property was governed by the law of her country, in which she had never entered except during one short visit 60 years before her death. Ireland was not even a separate political until 62 years of death. She was ignorant of the succession law of Ireland. The reasoning on which such a remarkable result is reached are interesting. First, the judge is required by the English law to law of the domicile, then he allows the law of the domicile to be supplanted by the law of nationality. Then, upon discovering the law of nationality is meaningless, the judge throws himself back on the domicile of origin and thus determine the rights of the parties by a legal system which is neither the national law nor the law of the domicile as required by the English private internal law, so the judgment seems to be superfluous. That is all for today. I hope you like this. Next class will deeply study about the case laws. Till then, be safe. Thank you.